We'll start with the Executive Council of Australian Jury.
I'm Peter Wertheim. I'm the co-CEO of the Executive Council of Australian Jury, and I'm here with Simone Abel, who will introduce herself.
Thank you.
Hi, I'm Simone Abel and I'm Head of Legal at the Executive Council of Australian Jury.
Thanks. And the Zionist Federation of Australia, also by video conference today. Mr. Liebler? No. Mr. Casudo? Hi.
I'm Casudo, CEO of the Zionist Federation of Australia.
Thank you. And the Australian Israel and Jewish Affairs Council, Dr. Rubenstein. I think you're joining us by teleconference, is that right?
Yes, I am. I'm afraid the video link wasn't working, so I apologise. Dr. Colin Rubenstein, I'm Executive Director of the Australia, Israel and Jewish Affairs Council.
Thank you so much for joining us. I might just ask broadcasting if you can turn the volume up a little bit on the witnesses. Thank you. That will make it easier for us to hear. Thank you all for joining us today. Before we go to questions from the senators, would any of the organisations like to make a brief opening statement? I can start with the Executive Council of Australian Jury.
Hi, I'll do that. Thank you.
Thank you.
We would like to acknowledge the traditional custodians of all the lands we meet on today and to pay our respects to all elders past and present and to the children of today who are the elders of our future. This inquiry is a crucial first step for the Australian Jewish community in seeking accountability for the rise in anti-Semitic incidents and discourse on Australian university campuses and the culture of Jew hatred that is becoming normalised in academic settings. The Executive Council of Australian Jury is the peak elected representative body of the Australian Jewish community. For the last 35 years, we have produced and published the annual report on anti-Semitism in Australia, which tracks the number and type of anti-Semitic incidents occurring in Australia each year and trends in anti-Semitic discourse. Anti-Semitism on university campuses is not a new phenomenon. Jewish student groups and academic staff have for years been meeting university leaders to warn them of the increasingly toxic circumstances under which they have been forced to work and study. They have been politely and sympathetically heard, but their warnings have mostly been ignored. Over the last 11 months, they have felt betrayed by the university leadership. Universities have tended to insist on complainants proving a legal standard of discrimination or vilification, even when their codes of conduct plainly do not require this. While telling Jewish students and staff they have not been vilified, they have suggested that they drop specific subjects, do their studies or work remotely because it's unsafe for them to be on campus. The mess these universities are now in is the predictable outcome of their approach. Yet these university leaders appear to have learned nothing. The GO8 submission to this inquiry shows that they are still locked into the same old mindset. They still equate menacing, harassing and abusive behaviour by students, staff and off-campus agitators with free speech. They still pretend that calls for the destruction of Israel or the Jewish people or the use of hateful and demonising language towards Jews and Israelis is acceptable political discourse, and they reflexively mention Islamophobia every time they mention anti-Semitism, creating a false competition between two abhorrent types of hatred, where not a single one of the encampments has been accused of engaging in Islamophobia. We know anti-Semitism when we see it or experience it. Attempts to negate or minimise our lived experience or to try to define it for us are a form of misappropriation and distortion that would never be tolerated with reference to any other minority group. It is for this reason that, with the exception of a handful of Jewish fringe mini-groups, all of the Jewish organisations and individuals who have made submissions to your inquiry and those who have told us that they have made de-identified submissions have supported a judicial inquiry. Universities used to be places where the unbiased pursuit of truth in good faith was considered a virtue. If we want the truth to emerge about the shadow that anti-Semitism has cast over the physical and online spaces at universities, we cannot leave it to those who have failed their Jewish students and staff so comprehensively over so many years to investigate themselves. Nor can we leave it, sadly, to the Australian Human Rights Commission, a body which has published a self-serving definition of anti-Semitism that has been manufactured by an anti-Israel group. For those of us who still believe that the truth matters, a judicial inquiry is the only way forward. Thank you.
Thank you very much. Mr. Casuto.
Thank you very much. I'd also like to acknowledge I'm joining from Wurundjeri land of the Eastern Kulin Nation, and I'd like to acknowledge our First Nations who, just like the Jewish people, have had a continual connection and presence in their land for thousands of years. Senators, thank you for this important opportunity. I'm Alon Casuto. I'm CEO of the Zionist Federation of Australia, an elected representative body of the Australian Jewish community. The ZFA recommends that the Senate committee endorse the bill for a commission of inquiry into anti-Semitism at Australian universities that can compel witnesses under oath and establish best practice measures for all universities. Senators, it's undeniable that since October 7th, there's been an explosion of hostile, violent, and anti-Semitic incidents on campuses across Australia. This is just a very small sample of what Jewish students and staff have had to put up with on campuses recently. Nazi salutes at an ANU meeting, chants of, and I'm so sorry to have to use these words, fuck the Zionists and fuck you Zionist dogs at Deakin University.
Mr. Casuto,
Protesters.
Mr. Casuto, I know that language is really offensive to you, but also to others. And perhaps if there's some evidence like that, you can give it to us in writing, and then we can. I apologise for pulling you up. I know that it's really you really want to stress how awful that language is, but there's parliamentary proceedings I need to manage today. But thank you for understanding that.
I won't be using that language again. And I would
thank
like
you,
to
Mr.
hope
Casuto. I appreciate that.
Protesters expressing support for Hamas and calling for Jews to be barred from campus at Melbourne University. Now, this eruption of anti-Semitism didn't come out of nowhere, and it did not come off a low base. An independent survey of Jewish students that we commissioned in April 23 found that 64% of Jewish students experienced anti-Semitism firsthand. At ANU, it hit a staggering 84%. 57% of Jewish students hid their identity to avoid anti-Semitism. 85% of the students who've been targeted didn't even bother filing a complaint because they thought that the university wouldn't take them seriously. Now, we shared these results with university leaders in August of 23, and now the situation is significantly worse. No other minority would be expected to put up with the sheer scale of hatred that we have witnessed on our campuses. Calling for a judicial inquiry is not about curtailing academic freedom. Jewish students and academics are simply asking for the same protections as every other minority. Now, what distinguishes the universities that managed the situation effectively from those that didn't is strong leadership. Allowing a UK-listed terrorist organisation and extremist group, Hizb ut-Tahrir, on campus to participate in protests at UCID is not strong leadership. Overturning the expulsion of an ANU student who declared on ABC radio that Hamas, a terrorist organisation, deserves our unconditional support is not strong leadership. Universities are now responsible for fostering an environment on campuses where students have been given the green light to do or say whatever they want with zero consequences. There's a complete lack of trust by Jewish students and staff that their institutions have their safety as a priority. The only way for us to restore this trust is for a judicial inquiry to ensure that it can't be breached like this again. Now, some may argue that a judicial inquiry isn't needed. They may claim that universities already have protocols to handle anti-Semitism, but the lived experiences of Jewish students and staff, which we heard just now from AIJAC as well as from the Academic Alliance, tell a very different, far more troubling story. Senators, enough is enough. The situation on our campuses is untenable. And I'll finish with this final point, that the only way to confront this shameful stain on our academic institutions is through a judicial inquiry with Royal Commission-like powers for the sake of both our universities and their Jewish students and staff. Thank you.
Thank you very much. Dr. Rubenstein, do you have a brief opening statement you'd like to make?
I do. Thank you, Chair, and I apologise again. for the teleconference set up. I'll reiterate many of the themes conveyed by my colleagues. AIJAC first thanks the committee for reviewing this bill and urges it to recommend its passage. Establishing a commission of inquiry into anti-Semitism in Australian universities is urgent, given the spike in anti-Semitism we've seen since October 7 last year. Jewish students and staff have faced significant threats to their safety and well-being and have been obstructed from fully participating in campus life. The incidents are serious and numerous. Students have been harassed, filmed without consent, screamed at, followed, and even physically blocked from accessing parts of campuses. Some Jewish staff have required security protection. These alarming acts of anti-Semitism, combined with universities' apparent reluctance to address the issues robustly, make it clear that current measures, and indeed resolve, are totally insufficient. Existing proposals, such as the Human Rights Commission study into campus racism, fail adequately to address the severity and distinct nature of anti-Semitism. Overseas, inquiries have been conducted through investigations and task forces, for example, at prominent institutions like Columbia University and Stanford University. These efforts have yielded firm recommendations for addressing the untenable circumstances faced by many Jewish individuals and Israelis within the university environment. I would urge the committee to read through a summary of their conclusions and recommendations. But of course, in Australia, a fully fledged commission of inquiry would be even superior to individual universities undertaking their own inquiries. But those inquiries did document instances of faculty misusing their authority to stigmatise and humiliate Jewish students. Many Jewish students, faculty and staff reported that their complaints of misconduct were often dismissed by administrators, with some being directed to seek mental health counselling instead of receiving appropriate redress. The inquiries have revealed troubling findings about faculty members failing to act. Similar patterns, I would argue, have emerged in Australian universities where institutional indifference often results in the perception that anti-Semitism is acceptable. It's been normalised. This can't be allowed to continue. So really, to conclude, AIJAC believes the Commission of Inquiry, once established, should have three goals. One, to provide a comprehensive account of the state of anti-Semitism on university campuses in our country. Two, to rigorously assess the actions and inactions, for that matter, of university administrations to determine whether they have fulfilled their duty of care to staff and students and their legal and moral responsibilities in addressing anti-Semitism. And three, to conduct a thorough review of the regulatory framework governing universities in relation to anti-Semitism and other forms of intolerance, and to determine if immediate reforms are necessary to ensure compliance with the obligations identified in the previous objective. This recognition that the current rules and procedures are inadequate is as true in Australia as it is in the United States and necessitates an immediate and thorough review and overhaul to ensure they effectively address the crisis at hand. The inquiries conducted in the United States have produced vital recommendations that Australian universities must seriously consider adopting. So to conclude, AIJAC urges the committee to recommend that the Senate passes this bill. An appropriately empowered commission of inquiry is crucial to address this escalating anti-Semitism crisis we witness in our country. It is essential for protecting the safety and rights of Jewish students and staff and ensuring the integrity of Australia's higher education system. Without decisive action, this dangerous situation will only worsen, and it threatens to undermine the cohesion of our multicultural democracy. Thank you, Chair.
Thank you very much. I'll hand the call to Senator Henderson.
Thank you very much, Chair, and good morning, everyone. I really appreciate your attendance today. I want to just firstly turn to your evidence, Ms Abel, and you were particularly critical of the submission of the Group of 8. And I'm also looking at the submission of Universities Australia, where they say, I want to emphasise that universities are deeply committed to fostering safe, respectful and inclusive environments for all students, staff and campus users. Can you elaborate on your concerns about the submissions of both Universities Australia and also the Group of 8?
Yes, absolutely. Thanks, Senator Henderson. I think, there seems to be a lot of confusion around the application of the French Model Code, freedom of speech and protection from discrimination and racial vilification. And this has been a constant thread in how the universities have approached the issue of the rise of anti-Semitism on campuses over many years. Asserting that they are doing everything to protect free speech whilst also combating anti-Semitism. But of course, we all know that there's a point at which free speech crosses a line and becomes unlawful. And, at that point, invoking free speech protections actually damages the access of other people to their rights. And I think that the universities have shown a very confused approach, both in that submission and also just generally in their approaches at the various campuses. This is a recurrent issue. And we've seen it ourselves at the ECAJ in terms of how the universities have handled their complaints with students and staff. Often, for example, there was an informational session on Hamas that was hosted at the University of Sydney. Now, the session itself was not informational at all. It was really propagandist. We had 2 students there that we're aware of, and we saw lots of promotional materials around the university about the event. The promotional materials depicted the image of the Israeli tank that was captured by Hamas terrorists when they crossed the border into southern Israel on October 7th. It was a very violent image, which I'm sure you're all familiar with. And this is the kind of material that has been protected by free speech. We've had sight of complaints about that particular session, where the university has come back to the complainants and, it defended the propaganda materials around the campus and defended the session, saying it was a free speech situation and it was an informational session for people to learn more about what was happening. But in fact, having a session where we talk about Hamas at the same time as lauding it as a national resistance movement is clearly not an instance of free speech. It's quite obviously extremely intimidating and threatening to Jewish students and staff. And that's just an example, but that's the kind of thing that we've seen all over campuses in Australia since October 7th, but beforehand as well. And that's the same confused approach that's being taken in both of those submissions that you referred to.
Okay, Ms Abel, thank you. I'm sorry, we've obviously got limited time to get through lots of questions, but really appreciate your evidence today. Mr Casuto, I want to refer to NYU's change in policy at New York University, where the university has made a specific policy saying their non-discrimination and anti-harassment policy cannot be shielded by using Zionist as a substitute or code word for Jew or Israeli, excluding Zionists from an open event, calling for the death of Zionists, applying a no-Zionist litmus test for participation in any NYU activity is not allowed. And I'm referring to a statement by the NYU published on the website on the 27th of August 2024. Is this not an example of where universities have fundamentally failed Jewish students by allowing this sort of language to fuel anti-Semitism on a number of university campuses?
Thank you, Senator Henderson. Listen, we're here today, even having this inquiry, this discussion, because there is a crisis at universities across Australia, a crisis of anti-Semitism that is shown to be something that every Jewish student across different campuses is experiencing. So there's a systemic failure to understand what it means to be a Jewish student and staff member on campus and the discrimination that they are experiencing. Now, there seems to be a real confusion around this point of anti-Semitism versus anti-Zionism. What we would say is that this is not about freedom of speech. This is actually about hate speech and about racism. And a vast majority of Jews in Australia identify as Zionists. They have a close and personal relationship with Israel. You'd be hard-pressed to find Jewish people in Australia who don't have family and friends living there. And Zionism, contrary to popular belief, is not some modern movement that started in the 19th century. It's actually a fundamental Jewish value that's existed for thousands of years, and it's the Jewish people's connection to Israel. It would take a very creative and reckless person or very political actor to tell me that anti-Zionism is completely incapable of being anti-Semitism. And so when we see Monash protesters saying that Zionists are not welcome on campus, and the majority of Jews read that to say Jews are not welcome on campus. When we hear that all Zionists are terrorists, we hear that to mean a majority of Australian Jews are terrorists. When the erasure of Israel is called for on campuses, most Jews read that in only one way, which is we are seeking the genocide of your family and your friends and your people in the state of Israel, where a majority of the Jews of the world live. Now, ANU students performing Nazi gestures has nothing to do with Zionism. That is pure anti-Semitism. Similarly, at Deakin University, where students wearing kippot and other identifiable Jewish symbols sworn at and, cursed at and attacked, that is pure anti-Semitism. Calling for Jews to be barred at Melbourne University is not anti-Zionism, it's anti-Semitism. So we see endless examples of where, under the auspices of freedom of speech or political protests, there is vile anti-Semitism taking root at our universities. And fundamentally, if you're endorsing and supporting Hamas, a genocidal terrorist organisation hell-bent on the destruction of the Jewish people and the state of Israel, that is anti-Semitism. And Mike Burgess' comments made that clear, as did the Prime Minister's, and we are absolutely clear in what we're saying. We have no ambitions to curtail any type of freedom of speech. We have ambitions to stop hate speech and anti-Semitism on campuses across Australia.
So what do you say when you hear universities argue that they're doing everything to protect all students and that they have a zero-tolerance approach to anti-Semitism on campus?
I would say that the lived experience of Jewish students and staff demonstrate that that's manifestly wrong, or that they are simply incapable of addressing this systemic, deeply rooted issue, which is why we need to no longer rely on individual leaders and universities to address this. This actually needs to be dealt with at the highest levels of government and have a real clarity of both what is the expectation of university leadership when it comes to anti-Semitism, but also modes of best practice that can be that can set the standards for how to deal with anti-Semitism across Australia, because we have seen a difference between some universities who've dealt with it effectively and others who've been completely absent and unable or unwilling to deal with it, which has resulted in really, quite frankly, a complete failure in their duty of care to university students and staff.
Thank you very much. I will, Dr. Rubenstein, could you please give me, in a nutshell, your concerns about the way universities are currently dealing with anti-Semitism and why judicial inquiry is so important?
Thank you, Senator Henderson. Look, the evidence that's been produced, I think, overwhelmingly demonstrates the proposition that the university response has been lackadaisical, ineffective, lacking duty of care, and almost tantamount to the normalisation of anti-Israel bias and anti-Semitic behaviour on campus, implicitly acquiescing in the grotesque anti-Semitic behaviour that we've seen spread across the universities in our country. The notion, as the previous Mr. Casuto pointed out, that it's only Zionists who are being attacked, not Jews, is preposterous. Anti-Zionism is tantamount to anti-Semitism. I think anybody cognizant with the realities understands that the existence and commitment to the state of Israel is a core aspect of Jewish identity, and anti-Zionism inherently is anti-Semitism today. So from the river to the sea, a global intifada, this is anti-Semitism on steroids. So we have to really deplore the failure of the universities even to comply with their own rules and regulations. The head of ASIO has pointed out that Australia is in a situation of, escalated terrorism alert from possible to probable. Any individual or organisations endorsing or supporting organisations like Hamas, which is a genocidal death cult, illegal, prescribed in Australia, as is Hezbollah, are really treading on thin waters. And what we're seeing is the espousal of hatred and vilification and even incitement to violence by various individuals on campus, and university administrations simply failing to respond adequately. And that's why I've suggested to the committee having a look at some of the recommendations that have come out of the American situation from inquiries at Columbia and Stanford. I was certainly witness in the mid-70s the protest at Columbia University. And in a way, so much of this goes back to the 1975 Shameful Zionism as Racism resolution at the United Nations, which is emphatically revoked, of course. Yep. And I'm proud to say, as an Australian should be proud that it was the Labor government and Prime Minister Hawke who led the revocation of that iniquitous resolution.
Mr. Rubenstein, I'm sorry to cut in. I've just got very, very limited time, but thank you. I just want to quickly move to the Zionist Federation of Australia's statement, Mr. Casido, which was issued on the 29th of May 2024, calling for the University of Sydney Vice-Chancellor Mark Scott to resign. Could you explain why you've taken that position?
So fundamentally, I think we heard from the Jewish students directly. Mark Scott failed in his duty. For weeks, anti-Israel protests calling for an intifada and for ethnic cleansing of Jews were taking place on his campus, and the university under his leadership completely failed to ensure the safe environment for Jewish students and staff. So when you think about Mark Scott's responsibility as the leader and the shadow that he casts over that university, which, as we heard from the students directly, was the worst of all the universities, the university capitulated to intimidation tactics of these protesters. The individuals were ignoring university rules. They were threatening and intimidating Jewish students. They were encouraging children to chant about ethnic cleansing of Jews, and they've been rewarded for their actions. A lot of their demands were met. There were basically encampment members whose objectives were to exclude Jews from Sydney University who were invited to join a working group. And part of this is, in a sense, a reflection of the systemic breakdown of the systems of universities that are meant to deal exactly with these issues. And so what that showed us is that there was a lack of leadership, a lack of willingness to apply existing rules and standards, but also complete capitulation in the face of intimidation. So really, I think one of the biggest issues is that Mark Scott's engagement with Jewish and Israeli students was extremely substandard, to put it mildly. There was no invitation for them to join the working group. You heard earlier about his attitude towards Jewish students, and that provided anti-Israel protesters with a powerful lesson and a disturbing lesson that set the tone for universities across Australia, that intimidation works and that hatred gets results. And he delivered this message that basically Jewish students and staff's views and feelings and safety are not a concern to him. And I think that is an absolute travesty, and it demands a change in leadership in order to re-establish a safe environment for Jewish students and staff.
All right, yes, I will need to pass the call around. Thanks, Chair.
Thank you very much for your evidence and your submissions today. As you would be aware, a commission of inquiry would take some time to establish, and then for investigations or hearings and then recommendations to be made and implemented. In terms of some of the steps that might be able to be taken now, there's been recommendations in some of your evidence and also from the Special Envoy to combat anti-Semitism about some urgent actions that have been recommended. I want to ask a little bit about that. In terms of a best practice policy for universities or something set up so universities are encouraged to or required to put best practice in place, is that something that you're seeking to be done immediately without necessarily going through the Commission of Inquiry? I guess what I'm trying to do is separate out the things that could be done, immediately or urgently to combat what is happening right now on campuses. I think everyone might have a view on that, so we might start firstly with Mr. Witheram.
Thank you, Chair. Look, there are some immediate things that can be done, but these are not new. They have been put to universities repeatedly over the years. I've personally attended meetings with students and staff when they've met with the leadership of universities and put these proposals to them over many years. It's really, I think, important that certain things are done immediately, but it's also equally important that we don't ignore the underlying issues. Very often, even when universities express a preparedness and a willingness to look at this problem seriously and to try to address it, they find themselves hamstrung by a whole array of legal and policy constraints that limit their freedom of action. It may be something in the relevant enterprise bargaining agreement, or it may be something in one of their other policies, or it may be something in the legislation under which the university is constituted, or the bylaws. And that is why, Chair, we need a judicial inquiry, because a judicial inquiry would be uniquely placed to look at that broad range of legal and policy constraints that go well beyond the legislation that is within the specialist remit of the Australian Human Rights Commission, and look at the broad range of legal and policy considerations that are brought to bear when considering these issues, and can make recommendations, if necessary, for the relevant reforms that are needed, and also for the relevant policy changes and attitudinal and cultural changes that are needed. I'll just point to one example. At the University of Sydney, some years ago, the university actually did the right thing and terminated the employment of an academic who had been engaged in an especially egregious series of behaviours of an anti-Semitic nature. The academic, with the support of the union, challenged that dismissal, and it ran through 4 court cases over a number of years before the matter was finally resolved in the university's favour. It shouldn't have to come to that. And if we're just looking at some of the remedial measures that you're alluding to, Chair, and ignoring those underlying issues, we're not going to really address the problem, and nothing fundamentally will change. And in 10 or 20 years' time, we'll be looking back at this inquiry as a missed opportunity. We have to have that judicial inquiry to look at that broad range of legal and policy considerations that are constraining universities in their conduct, in their freedom of action, even when they're willing and able to address these problems.
Okay. The other question I had, I put to the other. Sorry, Mr. Casuto.
Can I respond to that question?
Yeah, of course you can. Thank you.
So just to your earlier question around what can be done. So we believe that one of the insights from the widespread survey that we conducted is that students are simply not confident that if they make a complaint, anything will be done about it. So we do believe that there's a need for a thorough examination of the complaints procedure and how to restore confidence in that complaint procedure. There should be a national model to standardise how complaints about discrimination against Jewish students are handled. In some universities, anti-Semitism is not even one of the options that can be ticked when you're putting forward a complaint around against discrimination. We also believe there should be an oversight body, like an ombudsman, to whom students who are unsatisfied can make a complaint. We also think that there are a lot of policies that are simply not being enforced. So I think university administration have the ability to take action, but are simply not doing so. And so we need to examine why that's the case. And we also think that there's a need for education about modern anti-Semitism, because clearly a lot of this is born out of the fact that there is a lack of understanding of what it means to be discriminated against as a Jewish student or staff member at universities, in particular by those who are handling complaints. We know that there are examples of complaints that were dismissed because of a lack of understanding of the Jewish experience on campus. And finally, we'd recommend that all universities, like Monash and Melbourne University have already done, adopt the International Holocaust Remembrance Alliance definition on anti-Semitism. We think that's a very important low-hanging fruit and quick next step in terms of creating a standardised understanding of anti-Semitism that's already embraced on a bipartisan basis by the federal, New South Wales and Victorian government, as well as I mentioned, universities that have already adopted it. And this definition is widely recognised by governments as well as Holocaust experts globally, and it clearly states what anti-Semitism is and what it's not. And any criticism of that definition is, I think, generally because of willful ignorance.
Thank you. That's really helpful. I will hand over the call, perhaps on notice, if you could give the committee your views around the government's introduced legislation to establish a national student ombudsman. There'll be an inquiry into that bill, I believe, in another committee. But if you could maybe give us on notice your views about the capacity of that organisation when it's set up to deal with some of the complaints handling you've expressed, that would be helpful. But I will hand over the call to the Deputy Chair.
Thank you, Chair. My first question relates to a point that was raised by the Chair, and that is that it would take some time for a judicial inquiry to complete its investigations, to assess all the evidence, to gather the evidence, to hear from relevant witnesses, and then to make recommendations. And on the face of it, that is obviously correct. However, I wanted to put to you the proposition when I was reflecting on that the announcement, the initiation of an independent judicial inquiry with the power to take evidence from students and staff, including on a confidential basis, with the power to require witnesses to appear, with the power to actually access documents, require documents to be produced. The actual initiation of that inquiry itself could really act as a positive recalibration of what is happening on our campuses and really put the high levels of management of those campuses on notice that they really must look very deeply at how they respond to these issues. So I want to put that proposition to you and get your response to it. If I could start with you, Mr. Wertheim.
I fully support what you just put with respect, Senator. It will absolutely change the atmospherics. It will create the right cultural environment within which these considerations will be undertaken. And it will also, I think, act as a spur to putting forward some of the interim measures that we've been talking about in terms of expanded powers of the Ombudsman, improved complaints procedures, better understanding of what anti-Semitism is. I would also add education programs to university administrators so that they understand not just the need to adopt the definition, but what it means and what it doesn't mean and so on. All of those things are helpful. But as I said earlier, they will not address the underlying issue of the broader legal and other constraints under which universities operate. And that is for an inquiry, and yes, it might take a little longer to do that, but it's equally necessary. So yes, I agree that the announcement will do everything that you've said that it will do and more. It will also set the right parameters, I think, for examining the underlying structural and cultural constraints on universities and getting the right outcome in the long run. I think that two-step process is the way to go, and for the reasons that you've outlined.
Thank you. Ms Abel? Yeah.
Yes. Hi. Thanks, Senator Scarr. I would also just add to everything that's been said, we shouldn't be under any illusions about how fast-moving any alternative would be in any event or how effective it would be. As you've all had experience of the Change the Course report, back in 2017, there was this bold idea that we would get to the bottom of this systemic issue of sexual violence on campuses. Here we are in 2024, and we have yet to see a National Student Ombudsman introduced. So this idea that a judicial inquiry would be so much more slow-moving than any alternative, I think, is just not borne out by reality. And I agree with everything you've said. We've, in fact, already seen anecdotally just the fact of this Senate inquiry has resulted in more responsiveness from universities around some of the issues that have been raised. So there's no question in my mind that having this process and ultimately moving towards a judicial inquiry will be highly effective. And the other thing I would just add is there are some serious systemic issues that universities have proven that they can't get to on their own. For example, issues like foreign interference, which you would have heard the Special Envoy talk about the other day, and also the embedded anti-Semitism in institutions that universities claim that they can't actually control. For example, some of the student publications, the student general meetings that have taken place. You would have no doubt heard about the student general meeting that happened at the University of Sydney, where a motion was passed, essentially condoning violent resistance by Hamas, and the meeting refused to condemn the acts of October 7th, and the university's response was that they couldn't really control this. So we know that actually there needs to be a greater level of external oversight to get to the bottom of this, and I have no doubt that this is the start of a process, but that we do ultimately need that judicial inquiry, because that will get at the truth of the situation.
Mr Cassuto.
Thank you. I think to really build on what's been said, this did not start on October 7th. It just got much, much worse. And we know this because we conducted our survey long before October 7th. There was an independent survey that reached hundreds and hundreds of Jewish students. 1 in 14 Jewish students across the country were surveyed, and a majority of them had experienced anti-Semitism on their campuses. Now, we know that's gotten a lot worse since the 7th of October. But after that survey, in April of 2023, we wrote to nearly all MPs, to senators, to university chancellors, and we offered the possibility of meetings. We met with a lot of different universities: Deakin, La Trobe, Macquarie, UNSW, Sydney University, UTS, UQ, and we had many other meetings scheduled that, unfortunately, because of the events on October 7th, had to be postponed. We also met with the Education Minister and Shadow Education Minister, and one of the challenges that we put to them is that there is a systemic breakdown of an ability to protect Jewish students and staff. Now, we know that since October 7th this got worse, but this has existed for years. The only way to put to put some accountability in place and to drive systemic change is through judicial inquiry, because we know that in the absence of that, it will continue for many more years. So this is really a line in the sand, and I'm glad that we are having this conversation today and that we are able to air this at the highest levels of government, because this systemic failure has been happening for years. And in order for it not to continue for many more years, it's time to shine a light on it and to demand some very serious systemic change.
Thank you. And Dr. Rubinstein.
Senator, yes, I endorse your proposition completely, and the measures recommended by my colleagues. I would simply add that there are things that need to be done in the interim, and this is where the US experience and recommendations are useful. For example, colleges, universities should forbid conduct that disrupts teaching, learning and research. They really shouldn't allow anyone to interfere with their core activities through classroom disruptions or noisy demonstrations or actions designed to prevent invited speakers from expressing their views. They should resist any efforts to close off campus public spaces for any individuals or groups. They should absolutely enforce the rules that they have, because rules mean nothing unless they're enforced, and unfortunately we're seeing too much of this in action, lackadaisical response. And moreover, they should be checking student ID cards to make sure no outside aggressors or radical extreme groups are allowed into the protests or on the encampments, and obviously we've seen that in Australia. And consider introducing, a system of escalating punishment for serious violations. These are all things that need to be considered and addressed and acted on in the interim. But to get to the bottom of this and to deal with the systemic failure and problems that we have, there's no alternative but the judicial inquiry which we're discussing today.
Okay, well, just one more question, and following on from that last statement you made, Dr. Rubenstein, in relation there's no alternative but a judicial inquiry. I note that some stakeholders have said the Australian Human Rights Commission study of racism is perhaps an alternative forum. As I understand it, and I've read the Executive Council of Australian Juries submission, there seems to be a lack of confidence. Just as a matter of fact, there's a lack of confidence in the Jewish community with respect to the Australian Human Rights Commission being able at this point in time to conduct an appropriate inquiry. I'd just like to give an opportunity for each of the witnesses to comment on why we need to have an independent judicial inquiry as opposed to leaving it to the Australian Human Rights Commission study of racism. Mr Wertheim?
Yes, thank you. Well,
Sorry,
just to reiterate a point I made earlier.
fairly brief as well. Apologies.
Sorry, the Chair just for the benefit of witnesses, the Chair's just asked if witnesses could keep the answers brief. Feel free to also provide additional information on notice as well.
Just running a little behind.
We're just running a little bit behind.
Thanks.
Mr Wertheim.
Yes, the Human Rights Commission has a limited remit. Its specialty is the anti-discrimination legislation. And as we've been discussing earlier, what's called for is a much broader investigation that might look at EVAs, the Fair Work Act, the acts under which universities are constituted, things that go well beyond the specialty of the Human Rights Commission. So that's the first point. The second point is, yes, there is a lack of confidence because of an unfortunate history in recent years with the Human Rights Commission being perceived to have downplayed or ignored anti-Semitism. The Human Rights Commission has a new president. We have some hope that under new leadership that situation will be repaired, but it will take some time. And in the interim, we have to get moving on this issue. And while things are changing at the Human Rights Commission, we need to get underway with something that the Jewish students, Jewish staff and the Jewish community are going to have confidence in. And unfortunately, at the moment, that's not the Human Rights Commission. Only a judicial inquiry will satisfy that and will elicit the sort of confidence that will enable Jewish students and staff and other members of the community who've experienced or witnessed anti-Semitic incidents at universities to come forward.
Any other quick contributions? And again, feel free to take on notice, but if there's any other very quick contributions on that question.
I'll just say that the Australian Human Rights Commission has been pretty much absent as far as the Jewish community is concerned since the 7th of October, as we've seen an onslaught of anti-Semitism. I mean, just by way of example, we wrote to the Human Rights Commissioner in May. We heard back from a junior research assistant in June saying that they would reach out to us, and we haven't heard from them since. So I'd say that this is indicative of their sense of urgency and capacity to deal with this national systemic eruption in anti-Semitism, and that is why I think our community has a very low level of confidence that they have the capability to deal with what is an enormous problem for our nation.
And Senator,
if I could just briefly add, it's got a broad brush approach without a specific focus on anti-Semitism, and so it'll fail to address the unique aspects of anti-Semitism. And finally, really, it has no powers to compel vice-chancellors and other administrators to provide evidence. So I certainly think it's inadequate to deal with this problem.
Very quickly, and then we'll have to wrap up. Sorry,
last contribution.
Yeah, thank you.
I think the judicial inquiry will also be helpful for the Australian Human Rights Commission, because it will necessarily elicit information that may well inform any report or study that they conduct. So it doesn't need to be, one over the other. We believe in the Jewish community that a broad brush, generic approach to racism has proven ineffective, because we wouldn't be here otherwise. And the Racism It Stops With Me campaign of the Australian Human Rights Commission, that's been running now for a few years, is a prime example of that. And so, we believe that this judicial inquiry is absolutely essential, which isn't in any way to diminish our hope that we can rebuild a relationship and rebuild our confidence in the Human Rights Commission under new leadership. We think there's great potential there, but we think that there is a serious issue here that needs to be properly explored, and that information will be helpful for the Commission and for the government and for universities.
Thank you very much, and thanks for all of you for staying on the line a little bit longer for us.